Hi again, Joseph. I will now be presenting my oral submissions for assignment number 2. So part 1, overview. Should the applicant be granted an interim remedy by the Human Rights Tribunal of Ontario for an exemption of Rule 68, as stated in the Condominium Corporation Rules, and created and enforced by Carleton Condominium Corporation Limited, because of the fact that he is disabled and physically cannot comply with this particular rule? So the facts of the case. The applicant, Mr. Jason Smith, currently resides in a condominium at 245 Carling Avenue in Ottawa, Ontario, with his spouse, Lori. The building in which the condominium is located and is owned by Carleton Condominium Corporation Limited, and Mr. Smith resides in Unit 514, which is owned by his wife's parents. Mr. Smith is also severely disabled as a result of a serious car accident which occurred in May 2007. Mr. Smith sustained multiple injuries, including fractures to his spine, broken ribs, major cuts, damage to his hips, and third-degree chemical burns to his head, eyes, and body. This has caused him to suffer from several long-term disabilities, and he is still currently recovering from the injuries that he sustained in this accident. In addition, Mr. Smith falls into the category of catastrophic impairment, according to Section 40, Sub 4 of the Statutory Accident Benefit Schedule under the Insurance Act. Catastrophic impairment includes conditions such as paraplegia or quadriplegia, multiple amputations, loss of vision in both eyes, or a combination of impairments that, when combined together, result in 55% loss of function. Since the accident occurred, Mr. Smith has undergone extensive therapy for both the physical and psychological injuries he has sustained. He was also advised by his doctors to get a dog in order to assist him in the therapy and recovery process. Mr. Smith followed this recommendation and now has a German Shepherd named Sunny. Mr. Smith states that Sunny is very well trained and assists him greatly because he has been trained to lead Mr. Smith in such a way as to avoid obstacles that Mr. Smith cannot see for himself due to a lack of perception and no vision in his right eye. Sunny's presence has also helped Mr. Smith greatly in improving the effects of his post-traumatic stress disorder. Upon moving into his condominium in January 2009, Mr. Smith was immediately fined for a breach of Rule 68 of the Condominium Corporation Rules, which states, when on the common elements, including an elevator, all pets shall be carried or transported in a wagon or a cart. Mr. Smith tried to explain to the building management how difficult it is for him to comply with this rule, given his physical limitations. However, the management refused to exempt him from this rule and would not explain the rationale behind it to him when asked to do so. Mr. Smith has tried his best to comply with this rule. However, he has experienced considerable pain as a result of having to constantly pull Sunny in a cart. He has been advised by his doctors that continuing to do this on a regular basis will further aggravate his medical conditions. In addition, Mr. Smith finds it extremely difficult to lift his dog into the cart as the dog is also quite heavy. As Mr. Smith is unable to work due to his injuries, his wife tries to help getting the dog into the cart as often as she is able to. However, she works full-time and is not always available to help Mr. Smith with the dog. As the issue continues to worsen, Mr. Smith was forced to contact the condominium again in the spring of 2010. This time he provided them with medical notes from his doctors concerning his medical condition, to which the condominium simply ignored. Mr. Smith continued to try to persuade them to change their minds, and even had his lawyer contact them to determine why he could not be exempt from this rule. The condominium management never provided him with a valid reason as to why he could not be exempt from it. Mr. Smith was then involved in another automobile accident in October 2010, which was similar in nature to the first accident. Although he did not sustain any further serious injuries, this accident contributed to further worsening his conditions, both physically and psychologically, and has set back his recovery process. Finally, Mr. Smith was forced to have surgery to have his right eye removed in May 2011 and also underwent surgery for his right shoulder. This means that his physical limitations will continue to worsen if he is forced to continue to follow Rule 68, and his disabilities will continue to deteriorate as this rule is also significantly contributing to the worsening of his physical condition and well-being. So Part 3, position on the issues. Mr. Jason Smith should be granted an interim remedy by the Human Rights Tribunal, exempting him from Rule 68 due to the fact that he is disabled and is physically unable to comply with this particular rule. He would like to rely on Sections 2 sub 1 and 2 of the Human Rights Code to support his claim that he should be granted an interim remedy exempting him from Rule 68. Section 2 sub 1 of the Human Rights Code states, "Every person has a right to equal treatment with respect to the occupancy of accommodation without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, age, marital status, family status, disability, or the receipt of public assistance." Section 2 of the Human Rights Code states, "Every person who occupies accommodation has a right to freedom from harassment by the landlord or agent of the landlord or by an occupant of the same building because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, age, marital status, family status, disability, or the receipt of public assistance." It is clearly stated in both sections that every individual who occupies accommodation has a right to equal treatment as well as a right to freedom from harassment because of various factors including disability. Therefore, since Mr. Smith is disabled and cannot comply with Rule 68, the condominium must acknowledge and recognize this issue and try to accommodate Mr. Smith and his disabilities instead of discriminating against and harassing him. The condominium also appears to be in breach of both of these sections, and so this is another reason why Mr. Smith should be granted an interim remedy, which would exempt him from Rule 68. In addition, there are two cases in which Mr. Smith relies on to support his claim that he should be granted an interim remedy, and these cases are as follows. DeSalvo v. Halton Condominium Corporation, number 186, and TA v. 60 Montclair. So in conclusion, it is evident that the applicant, Mr. Smith, should be granted an interim remedy by the Human Rights Tribunal for an exemption of Rule 68. He should be exempt from this rule due to the fact that he is disabled and cannot physically comply with it. Both Sections 2 sub 1 and 2 of the Human Rights Code clearly outline that every individual who occupies accommodation has a right to equal treatment as well as a right to freedom from harassment based on various factors, including disability. As Mr. Smith is disabled and cannot comply with Rule 68 of the Condominium Corporation rules, the condominium must acknowledge and recognize this issue and try to accommodate Mr. Smith and his disabilities. In addition, there have been two cases which Mr. Smith has relied on to support his claim that he should be granted an interim remedy, and these cases are DeSalvo v. Halton Condominium Corporation number 186 and TA v. 60 Montclair. Mr. Smith should be granted an interim remedy for an exemption of Rule 68 because he is able to demonstrate that he is suffering from physical harm to his health and well-being as a direct result of having to comply with this rule. He is able to support this claim through all of the documented medical notes that his doctors have given him to provide to the condominium, advising them that he is unable to physically comply with Rule 68 as a result of his disabilities. Thanks very much.